Entrepreneurship to the Point on YouTube. The session will also be streaming live on YouTube. So if you are on YouTube, please feel free to engage as well, and we will answer all your questions. In the chat below, you will also have the opportunity to engage and ask questions. But also, while we getting through the introductions, can you also just let us know where you're from, and it would be great to hear from you and a little bit about yourself or your business. We'll definitely make sure that we have some hands on deck to focus on the chat group as well. So today's session is going to be on unpacking some of the legal questions entrepreneurs have. Through our program Property Point, we are working and supporting a lot of small businesses out there during this crisis. And as part of those sessions, we've been having a lot of legal clinics to be able to really delve and assist businesses with any of the legal questions they might have. How to, what do you do with your supplies if your suppliers are not paying? If you're in a pickle with your staff, what is the right legal process? Does my contracts have the right legalities in it in order to be able to focus on the elements, whether it's force majeure or anything else. So we've got Sharusha Mudley joining us from Bregman and Mudley Attorneys. She will be our expert today. And we've got Karin Storm from our Property Point team. She's an industry mentor. She will be engaging and asking Sharusha the questions. And we also have Charles van Biljon online to be able to ask any or answer any question related to the UIF. So one of the key factors that we've also been able to get from businesses is the challenges that they're having with the UIF process, whether it's the application process or just how it is currently working. So hopefully Charles will be able to provide us with additional insights. On this note, I'm going to hand over to Karin. She will be really just kicking off the session with Sharusha. And ideally, we want to be able to get to as many of your questions that we possibly can. If not, please do email us at info@ettp.co.za. That's info@ettp.co.za. Karin, over to you guys.
Thanks, Sean. You can see I dressed up nicely for the legal session. I see all our speakers are also dressed nicely. Thank you, Sharusha and Charles, for joining us. Sharusha, you've been doing great work with our program management teams and some of our small businesses in navigating legal issues that SMMEs are experiencing during this COVID time. Can you give us a bit of an overview? And you said to me earlier that there are recurring issues that many of the SMMEs experience. Are you able to give us a bit of an overview of what those typical recurring legal challenges are that SMMEs face in this time?
Afternoon all, afternoon Karin. Yeah, in doing work with you guys, I've come across a pattern or certain trends that are happening, and those relate to, as Sean hinted on, firstly, what am I going to do with my rent? So that's at the top of the list, is how do I pay my rent? The second is what do I deal with and how do I deal with my staff? I can't afford to pay their salaries. Those type of questions, all revolving around employment law and employees. And the third, relating to supplier, creditors, debtors. How do I collect my debt? How do I pay my debt? And all the questions surrounding monies due and monies owing.
Okay, so let's start with the rent questions.
Yeah,
typically businesses own a premises or they rent a premises from a landlord. They have an existing lease in place, and now they can't occupy the office. The businesses can't trade. Do they still need to pay rent?
Well, it boils down to two things. Firstly, whether COVID is declared a force majeure event, in which instance it's my view that it is. This is on account of the fact that the president has declared it a pandemic in March, and then you look at your lease agreement. So some of the questions that we've been asked is, I can't pay my rent, what do I do? So the first thing any SME needs to look at is whether they have a written lease agreement. And in a written lease agreement, you may or you may not find that there is reference to what is called a force majeure clause. And a force majeure clause, in a nutshell, means it means an act of God, something that prohibits performance in terms of your lease agreement. In this instance, it would be the COVID-19 pandemic, and as a result, you cannot fully perform your obligations in terms of the lease agreement, and that would be obviously the payment of your rentals. So many clients have asked, well, I have this force majeure clause, and what do I do about that? Can I then not pay my rent? Can I activate that force majeure clause? Before I answer that, you also have the possibility of, if you don't have a force majeure clause, you have what is called, where it's not expressly provided in your lease agreement, you have what is called a supervening impossibility. That is the common law.
Just say that again.
Supervening impossibility, which is the equivalent of I can't pay my rent because of an act of God, or because there has been, it was events beyond my control. Okay, but the two are, in a way, you need to prove different objective tests for the both. So either way, you have either the force majeure clause or you have the supervening impossibility. The force majeure contained in a lease agreement, and the supervening impossibility is the common law position. So what would you do? Firstly, you need to understand that if you want to rely on the force majeure clause, there is the risk that the landlord could litigate against you or your company or however you're registered. And in litigating, you need to have grit to continue litigating. It has a ripple effect on whether or not you're going to secure alternative premises, your credit rating, all of that. If there is a order granted against you, then there's sureties attached to the lease agreement. So it's not as easy as saying, I want to raise force majeure as my defense. I don't want to pay my rent, or I can't pay my rent. So there has been a lot of talk, and there is it's quite rife out there that landlords, the property groups, have come to an agreement, and they are providing certain reliefs, and that would be either renegotiating the terms of your lease or allowing for deferred payments or payment arrangements. And in this day and age, considering this is not a one answer fits all situation, it is advisable that you negotiate with your landlord on some alternative rather than litigating, because understand that the courts are not fully functional yet. We anticipate there could be those test run cases or an influx of litigation relating to this, but we should be cautious to just start litigating when we are facing an economic crisis. So if you can come to an arrangement, check your lease agreement, see if there is a force majeure clause in place, and work with your landlord. The second is when there is a supervening impossibility in the common law, you need to everyone that are tenants needs to understand that the benchmark or the level of proof is a little bit higher. You need to prove that it was impossible for you to perform, that you couldn't perform any of your functions or as a tenant, so you couldn't earn any income. So in this regard, if you are for example, a IT company, you don't necessarily need premises to trade, so you may have a difficulty proving supervening impossibility.
So what about if, thank you. So what about if I was able to still earn an income, a reduced income perhaps, but it wasn't from my premises where my business normally operates from?
Yes, and that's what it boils down to. Either when the courts are going to test that, and they're going to check, well, were you able to pay something towards your rent? Did you mitigate any of the loss? Did you earn any income? All those factors will be taken into account if you decide that you are flatly not going to pay your rent. Raise force majeure as a defense. So it is a risk that you take. So each situation for its own, and bear in mind that the landlord may decide, well, you did earn an income, you should have made some contribution, we have offered you relief in some form, we are going to litigate. So it is a risk. It is a
So
risk.
we had Estienne de Klerk, who leads the newly formed property industry group. He was on a webinar with us explaining exactly the tenant relief that they've, in their group came up with. That was specifically for retail tenants. But I think the one important thing that he said there was to encourage tenants to engage with their landlords, to have the discussion, to find a solution. And what you're now saying as well, don't just assume that I'm not paying my rent because COVID is a force majeure event. Have the discussion, don't just assume. I see there was a question, someone saying, is there another term for force majeure?
Yeah, a supervening impossibility, or vis majeure, VISMAJOR. So the common law refers
Afrikaans
to,
people call it vis major.
there you go, vis major.
So you can look out for that in your lease agreement as well.
Yeah, it's an event beyond your control. In our lease agreement, in our law firm lease agreement, specifically provides for pandemics, and it specifically provides for quarantine. But it doesn't necessarily, and in another lease agreement I looked at, it provides that if the force majeure event, if the event beyond your control, if the act of God remains in place for longer than 3 months, then the agreement is terminated. Or 3 weeks, I believe. Yeah, it was 3 weeks. Then the agreement is terminated. So
automatically terminated.
Automatically terminated. And that's the advices we needed to look, and guide the client. In fact, it was one of your clients that we needed to look at. So each for its own, each set of circumstance needs to be considered. And correctly so, if the landlords are allowing, because if the major banks are passing on some leniency to the property groups or landlords, those landlords will certainly do the same insofar as their tenants. And it's a ripple effect, because they've got to pay their staff, they've got to pay their service providers. That ship also continues to somewhat trade. They may not have full trading at the moment, but they will have some tenants. So their services still need to go on. So in this unique situation and time that we're in, it's important that we all communicate.
Thank you. We have a question here coming in from the chat saying, can landlords force people to give them their bank statements to prove that they have not made money? So how will you determine whether I've earned an income or not?
Well, it boils down to a question of fact. And you have two options. The first is to deny the landlord the access to that information. And if you do that, it could lead to an adverse reaction from the landlord and say, well, I can't assess your credit or credit worthiness or discount or payment, deferred payment, if I don't have access to the true financial situation that you're in. So you can say no, but there's a risk. And an adverse reference. And if you say yes, then good for you. But can they force you? No, they can't force you. It's your information. You have a choice whether you want to give the landlord that information. It's a question of the aftermath, or what inference is drawn from your failure to do that.
And it's about long-term relationships. If you're going to have a long-term relationship with your landlord, it's probably better to try and find a solution than to just litigate or refuse to provide information. You said something interesting about your own lease agreement. That's probably the worst lease negotiation to do is with a legal company. But do you think leases will change? And what will people have to look out for? What should they have in a lease agreement to protect them for a time like this?
Yeah, it's an interesting question and a good one, because after this and during this time, we'll find that many lease agreements do change. They may altogether remold and rework force majeure clauses to such an extent that it specifically provides for certain events, or limiting the force majeure. And it also provides that, excuse the hard-it-does, but it may also provide that if a force majeure event is in place, it could provide for deadlock breaking mechanisms, reduced rentals, automatic payments, and all sorts of discounted payments that you could find. So it's a question of time, and we're eager to see what the new landscape of what lease agreements are going to look like. It could provide even, I was having a chat with a colleague, for rentals to include, and I don't know whether it is consumer friendly.
We seem to have lost Sharusha there for a minute. Sharusha, are you still there? I think once again, some technical difficulties. Karine, if we can maybe, as we wait for Sharusha, just do a quick introduction to Charles van Biljon as well. Charles will be assisting us in terms of any questions that we have on the UIF side. So while we're waiting for Sharusha to get back, I did pick up one question, some questions around UIF in the chat. Charles, can you maybe just give us a quick introduction to yourself while we wait?
Certainly. Thanks, guys. I appreciate being on here. I'd like to introduce myself. I'm from a company called the Guardian Employers Organization, the GEO. So the GEO is an employers organization that's, in terms of the Labor Relations Act, been registered, and it's been in operation since 1997. So what we do is we provide employers with labor law advice. We deal with collective bargaining, unions. We deal with the Department of Labor, discipline inquiries, representation at the CCMA. We deal with various different aspects of labor law.
Okay, great. So I'm just going to go into one of the questions that was asked, Charles, because I think a lot of businesses are trying to really focus on getting their UIF applications in and payments in. And Bongani asked the question, when applying through the UIF or TERS assistance, are you able to augment employee salaries if possible? Before we answer the question, Charles, can you just give us a quick overview around the UIF and TERS assistance package that is out there at the moment?
Certainly, Sean. I'd like to start off by saying that this is extremely uncharted waters for everyone. I certainly don't want to be in the government's shoes. They are trying their level best, I have to say that. But in saying that, they've also shifted the goalposts numerous times throughout this lockdown period. I mean, if we look at where we started, firstly, it started with a natural disaster benefit, or commonly called the NDB. And from there, it shifted to them also starting up TERS. Then the natural disaster benefit fell away. Then they started TERS with email applications, and that also has now fallen away. And they're actually now doing online submissions. So to apply for TERS is quite simple. You send an email, just a blank email to, the email address is COVID-19 TERS, TERS, at labor.gov.za. You should receive an automated reply within 3 to 4 minutes. And from that, you'll see they've got a link there to an online portal, which you open up and you just start your application process. One of the documents...
So let's just do that email address again. We'll put it in the chat as well, but it's COVID-19 TERS at
labor.gov.za.
.gov.za. Okay.
Correct, yes. So one of the documents you'll receive back in the automated reply, it's a PDF document, an online guide. So that's a step-by-step process where they basically outline the process as to how to apply, which information you need to put in, and which information you need to upload. For example, there's an Excel spreadsheet which you can make use of, which you need to convert to a CSV file before uploading it. But there are also, you need to upload banking details. There's various means and ways of doing it. Instead of using the Excel spreadsheet, for example, at the end, when you add in the employee's details, you can do it manually on the site, which was never before possible until they now redid the application process.
Okay. And The supplementation. So I guess the advice to businesses, if they are able to supplement the salaries of their employees, even though they're applying for the UIF, it's not 100% that salaries that UIF is paying out. What's the percentage? Because we've been also getting different feedback from businesses.
It varies. You see, the UIF sliding scale is anything between 38 to 60%. So they work it out on their calculations, and they then would do a lump sum payment. So there's various means how they can pay out. So there's three options. They can pay it out to you as the employer. They can pay it out directly to the employees if the employees' banking details are furnished. Or, for example, if you apply through a bargaining council, which I'll deal with in just a while, they pay it out to the bargaining council. If they pay it out to the employer, they pay it out in a lump sum. Once that lump sum is received, the Department of Labor should send you a spreadsheet with exactly how the lump sum is broken down. So so which employee would get which percentage or which amount. The reason I'm saying should is we have received, some of our members have received lump sum payments, but no spreadsheet. So they need to contact the Department of Labor immediately and say, I've received payment, but I don't know how much money to allocate to which employee.
Okay, so I know that they said after like it's 24 hours or 48 hours, you'll be able to receive that spreadsheet with the breakdown. We've got Sharusha back online. She had an electrical failure at her house, but she's back on a cell phone as well. I just want to see, Karin, before we maybe continue, if we have any other specific UIF questions.
Yeah, we'll also, I think one of the issues that Sharusha has been speaking to our businesses about is staff specifically, and UIF fits in with that. So we will at the end go back to speaking about UIF if people have other questions they want to raise later.
Yeah, I think if we can, we'll finishing off the session, we will move back to Sharusha on some, just finishing off the legal matters. And then we already have another UIF question that we'll come back to you, Shal. So yeah, Sharusha, apologies for that break in connection, but yeah, luckily we have backup plans.
Yeah, apologies from my side. It seems that the whole area has a power outage.
But not only have to deal with lockdown, but also with Eskom.
Definitely. Right.
I think we were speaking about rent. We've more or less covered that. One of the other issues that come up is monies that are due to SMMEs, work that they've done, products that they've delivered that haven't been paid, and yes, also monies that they owe. I think those were some general things that you were working with our businesses with.
Yes, some of the SMMEs have highlighted that obviously they haven't been paid for their services rendered prior to COVID. Some of them have performed some services during this period, limited, and have not been paid. Let's deal with that first. It's very important to understand that, you know, this is an economic downturn. Some of these companies that the SMEs are contracted with may find themselves in a similar bind and are unable to pay, you know, their overheads. So as you would want, you know, certain relaxations to be passed on to you for monies owed to you, or monies you owe, for example, on your bond, similarly, you should allow for some sort of leeway and allow these companies some opportunity to pay you. So what we're saying is communicate with, your first step is to communicate with those companies or suppliers or anyone that owes you money, and find out from them firstly when are they paying you? Are they able to make a contribution towards your amounts that are now owing to you? When do they anticipate to settle this amount? So come up with an arrangement to settle this. And thereafter, if you find that they don't honor the agreement, then you have to unfortunately proceed with a letter of demand. And from there, understand that you are in the collection world, in the litigation world, and you'll have to somehow try and get some legal advice so that you can try and collect your money. You may even find that during this time, some companies may even go insolvent, in which instance you'll have to then deal with the insolvent estate, put your claim in. But it's very trying time. So you must understand that if you can negotiate even a reduced amount, you must go ahead and do that. So that is in respect of any monies that are due to you as an SME. Yes.
I know I spoke to someone who said that they finished work just before lockdown, they've invoiced and they haven't been paid, but they're also scared to damage their relationship. As an SMME, they're very grateful for the work that they do have. And they don't want to just go ahead and send a letter of demand. So I think what you said importantly is to first pick up the phone, talk to someone. And often when you start with fire is fought with fire. So if you start with a letter of demand, they'll retaliate with their own legal. But if I had to resort to a letter of demand, what does that mean? Do I need a lawyer to draft that for me?
In most instances, it will be a simple letter saying you owe me these monies. You will follow a contract. If the contract provides for certain, payment terms, you'll alert them to the fact that they've, breached the payment terms of the contract. You'll refer them to the contract. And you'll say if this amounts are then not paid, you will then take formal legal steps for recovery. But that's a worst case scenario. We should be able to pick up the phone, speak to the creditors, accountants, and find out, can you tell me more or less when payments are coming in? Look, we're due to hear from the president today, in fact, how we all are going to be slowly reintroduced back into the world. And hopefully, once all sectors are back, we anticipate that we'll be able to all then try and, give companies time, give corporates time to recover some of the monies that's owed to them and also generate more income. So like I advised one of your SMEs for monies that were owing prior to COVID, we arranged that they wait a 60-day period. For example, just pick up the phone and understand where the debt is going to be. Because remember, the Prescription Act is there. And the Prescription Act says you've got 3 years from when the debt became due to institute legal proceedings. So you still have that option available to you. It's just a matter of, how quickly everybody's desperate to have that money in their bank accounts now. But understand that, we've got to be, it's a delicate situation now. You don't want to go into debt collecting phase as well.
So I think that ties in with the question we have here from Remy, one of our businesses from Chico Electrical. He says, hello, Sharusha, can I still claim for invoices older than 24 months? I think you've said yes.
Yes, because of the Prescription Act. You can
36 months.
36, 12, 24, more than 36 months. Well, you will have to assess whether some of the debt actually has prescribed. So if but a prescription is interrupted if the debtor has said, well, I acknowledge owing you money. So prescription works as follows. If the debt becomes due the next day, let's say you invoice a client today, from tomorrow the debt is due on presentation or the next day, depending on what your terms are. You count out your 3 years. However, let's say you're approaching your 36 months and the debtor then says, I do owe you the money. I acknowledge I owe you the money. That interrupts prescription and then starts the 3-year period once more. So it's a question of each case for itself again and checking whether or not debts are actually prescribed, whether there's been an interruption of that debt.
Okay. I see we have 56 participants joining us today. Thank you. You're welcome to post your questions for Sharusha or Shaul in the chat function and tell us where you're listening from. You can also subscribe to the Entrepreneurship to the Point newsletter at www.ettp.co.za. Sharusha, the one thing that I picked up that you said was people should read their contracts when they look at how to deal with monies that are owed to them. They should read their contract. And I think that's the one point that we picked up. SMMEs or maybe people in general don't read the contracts that they're signing.
Yes, and just before we go into that, we also were going to deal with, if you owe monies to certain people. So before, maybe I can answer that after I answer this one. But yes, in terms of your contracts, it's very important that you read them. And then there is some general tips that any company, any SME, anybody entering into a contract needs to pay attention to. You firstly have to understand what is the purpose of the contract. Is it the right contract you're entering into? Secondly, you need to look at the definitions, because definitions help interpret a contract. Some definitions are so important that cases are lost and won on them because it's a matter of interpretation. You need to understand your breach clauses, your termination clauses. When can you exit the agreement? What constitutes breach? Most of all, you need to look at your obligations as a contracting party to the agreement. Who is the party you're contracting with? You know, check if you can, check how strong they are in terms of their credit profile as well. So you need to do your own due diligence before you enter into a contract. Read your terms and conditions, understand whether there's any limitation of liability. So for example, you can't institute legal actions for these specific events. And if you are in doubt, don't sign the agreement. Don't just for the sake of it sign the agreement, because it could bind you to arduous clauses that you will not be able, or terms that you may not be able to fulfill. So for example, where monies are owed to you, or you owe monies, if it's linked to a contract, you need to first, as a starting point, check whether there's any clauses that prohibit or assist you. So go there first, have a look, see whether you can use any of those clauses. Then go back to the creditor or debtor and find out whether there's any payment holidays that can be made, payment arrangements that can be made, what's their financial position, where they're at insofar as, you know, you owe, or monies are owed to you, and where you owe monies, then come up with a compromise position. In this time, I suggest that because the courts are not fully functional, the attorneys are not fully back, you don't want to litigate unnecessarily. So do some work first and read your contracts, very important.
I think often SMMEs find it a daunting task to sign a contract. And once again, they're very thankful for getting any work. They almost feel like they don't want to ask questions about clauses in contracts. But it's your right. And the big corporates or the guys will, you know, there's often clauses that they are willing to negotiate on if you ask, and some of them are non-negotiable, but it's worth asking, checking that you understand it and that the clause works for you, because you're tying yourself to this long term, yourself in the business.
Yeah, and bear in mind, ignorance of the law is no excuse, as the Latin phrase goes. So if you are entering into any legal relationship, a contract, you know, it should at the end of the day reduce your intentions, your common intentions, your agreements down to writing. So it must meet both sides. So it's very important to engage with the other side to understand what is meant by certain clauses. And if they have their legal team that you can access, even as an SME, you must do that.
There's one interesting question. It takes us back actually to the whole force majeure. It's a question from Kosanati from Able Energy, one of our companies in KZN. Yes. Your neighbor there, Shoal. It says, hi, Sharusha, this is Kosanati. Can landlords activate force majeure to not pay rates and taxes to council? That's an interesting idea.
So rates and taxes, there's the rates and taxes is a nice question, because you can, as a tenant, say, well, I'm not paying any rates or taxes in connection with the leased premises. And then again, we're faced with the whole debate about whether it's right or wrong. But the landlord still has to pay that rates and taxes. There's no relaxation of rates and taxes. Those are utilities that still need to be paid, so to speak. And bear in mind that the period we're looking at, if you do owe rates and taxes, may fall into outside COVID period. It could be in arrears, because you charged in arrears for not just rates, taxes, but, you know, water and all of those things. So I would be hard pressed to say that you shouldn't, as a tenant, not pay your utilities, and landlords may as well say, look, despite force majeure, you're raising that these rates, taxes, and other utilities became payable prior to COVID, and in fact are still payable. You know,
So
there's argument even made, we were discussing it with a few other colleagues, that the landlords are actually acting as storage houses now, because your furniture is still there as a tenant. And you have other equipment that you may use or may not use that's still acting there. So like I said, it's a very, very touchy subject, but it's not automatic. The point is, it's not automatic that you can say, I'm raising force majeure as a defense.
Okay. There's one more question from Ofuneko. It's actually a comment that she made, to say that their accountant advised them that SARS can become a third-party debtor. They sent a letter of demand to our client mentioning the amount we owe to SARS, and within 2 days the company paid SARS directly. But I guess that's a situation of making a specific agreement in a specific situation.
Yeah, definitely. That's definitely that. There had to be an underlying agreement there, you know, because just on SARS, you know, there has been tax relaxations that are put in place. So we wouldn't know unless we have the full picture as to what is meant there.
Okay, so we've covered what to do with your rent, what to do when you owe money or someone owes you money, how to approach that. And then the tough one is staff, what to do with employees.
Yes.
What to do with paying employees, with keeping employees, retrenching, not retrenching. I think that's it becomes emotional because humans are involved, families are involved, people's livelihoods are involved. But I think there's lots of legal questions around that. And Shaul, come back, Shaul. But just tell us what the questions that you've had to deal with our businesses in terms of staff.
Well, at the top of the list. Oh, is it Shaul or me?
No, Sarusha, you can go. You can bring Shaul now. Thank you.
At the top of the list for me with your businesses that have approached me is I can only use some of my staff. I'm not using my full staff complement. I cannot pay any of my staff. So it's at what level of remuneration can an SME or SMME afford to pay its staff? So the first question is, I can't afford to pay my staff. What do I do? Mm-hmm. And I always say there's no accurate answer, but what you should look at, number one, is what you can pay. So whatever you can afford to pay, go ahead and pay that. Bear in mind that if you do have contracts of employment in place, you should look at those contracts and see if certain provisions can be relaxed by agreement. You must negotiate and you must try, you can't unilaterally implement any changes to where you have a contract of employment in place, because it's a contract at the end of the day. So if, for example, an employer wishes to reduce staff salaries by 40%, I'll give you an example. It's very important for that employer to negotiate with its employees and give a operational reason. And COVID is an operational reason. I cannot afford to pay your staff salaries because our turnover was low, etc. I can only do X, Y, Z. It is a temporary measure I wish to implement for a certain period of time. Can you agree? So look at the contract of employment first before you, as an employer, just unilaterally go ahead and reduce salaries. If there is no income coming in, then your second option, and this is in no particular order, but it's in a way sort of rolled out that way. But you need to then look at the government's relief schemes that are in place. You do have TERS, and I lost connection when Shaul was probably discussing that. I'm not too sure. So
we'll get back. Shaul will give us some more detailed information.
Yes, but you do have TERS, and from my theoretical understanding, TERS is a subsidy. You have to have a turnaround strategy, and it subsidizes your staff salaries. And then you get your UIF benefits. Your UIF benefits would then be temporary laying off staff. And Shaul can then, advise, but I believe it pays 3,500 Rand a flat rate. And then you get your temporary, that's your disaster management fund. And then you get your temporary laying off in UIF. So government your relief schemes, UIF, then look at that. And last but not least, if you find that you can, when you return to the office and the turnover is low, you then, if it's just become impossible to trade, you don't see yourself going further, you then can look at some sort of a restructure, retrenchments and so forth. So the government's relief schemes have been put in place as an alternative to retrenchments. You need to look at all alternatives as an employer before you just decide to retrench, shut down, or whatever you need to do. Even if you do shut down, TERS is there. And with the 500 billion rand injection cut up into various slices, we're due to see how this is going to be used in the various sectors. So yeah, it's not easy. It's not easy out there, but there are different ways you can approach the non-payment of staff salaries.
Okay, thank you, Sharusha. Charles, you'll be on the screen now. Maybe just tell us what, so you represent employers. So anyone employing any from 1 to unlimited number of people. What have you seen as typical questions, queries, challenges for businesses in this time?
Thanks, Karine. Yes, we, as you stated, the GEO doesn't look at the amount of employees that you employ. We help anyone that requires assistance. It could be, you could have 2 employees in your employ, or you could have 1,000. Regardless, you are more than welcome to go to the GEO's website. I'll just quickly give that. It's www.geo.org.za. You're more than welcome to go there. There's a contact us tab. So if you guys need any information, you guys are more than welcome to contact us. The GEO is a national company, so there's a lot of people, competent people that are willing to assist you. One of the questions that actually came up, which was spoken to, and it's actually quite a gray area, and it's very controversial at the moment, is leave. Leave is a big issue currently that a lot of people are battling with, because some say you cannot give leave during lockdown. Others say, yes, you can give leave during lockdown. I know the Department of Employment and Labour Minister also made a statement and said no leave should be given during this period. But if you have a look at the Basic Conditions of Employment Act, this is the act that governs conditions of employment between employers and employees. No agreement may be less favorable than the Basic Conditions of Employment. But if you look at that, at Section 20 of the Basic Conditions of Employment Act, and I'll read it for you quickly, I've got it out in front of me. Subsection 10, paragraph A and B says, annual leave must be taken in accordance with an agreement between the employer and employee, or if there is no agreement in terms of paragraph A at the time determined by the employer in accordance with this section. So it actually gives you the right to tell your employees when they need to take their leave. And therefore, my personal opinion is, yes, you can utilize employees' leave during this period. There was a directive that was sent out, amendment to the original directive that was sent out, which is in circulation, which also said that the Department of Employment and Labour is encouraging employers that if they have utilized employees' leave during this lockdown period, they can actually try and claim it back. So when you do, I can see there's a lot of TERS queries coming through. So I assume a lot of employers have already applied for TERS. So when you fill out the TERS, the employee's details, you'll see there is a section there to say remuneration received during lockdown. When you do it online, it actually specifies annual leave given during lockdown. So there you input the amount that you have paid your employees during the lockdown, and you then state on which day it was paid, and they will then reimburse you, which you can then recoup from the funds given to you. But it needs to be made very clear. Any money received from the UIF with regards to COVID-19 TERS is solely used for employees. You cannot touch that money for any other reason. That's very important, guys. When applying, you guys know that you need to sign or accept MOA, which is a memorandum of agreement. And just like Sharusha said, it's a contract between you and the UIF. So read through it and make sure you understand everything that is expected of both you and the Department of Labour. That's something that I cannot stress enough.
Charles, so, I mean, I've looked at that process myself and I've received some of those documents. Can you, in few simple steps, talk us through the process? So yes, you send the email. I know you spoke about it earlier, but maybe just the process of applying for the TERS.
Okay, no problem. So it's quite simple. As I stated, the email address is in the chat group. I see it was sent through. So you send a blank email to that email address. You'll receive an automated reply. And within the automated reply, there is a few documents. It's an Excel spreadsheet which contains the employee's details. It's an online guide, a PDF document, which step by step explains to you how to do the process. They've taken screenshots of the whole process and compiled it into a PDF. So that makes it quite simple as well. Then you get your another PDF document, or it's a Word document, that outlines how to convert the Excel spreadsheet into a CSV file, should you make use of the CSV file. So when you log into, I'll get back to the CSV file in a second. When you log into the online portal, sorry.
We're just doing a poll there. Sorry,
No,
Schultz.
no problem.
A poll there. We'd love to hear from the participants, the attendees today. Just tell us there on the online poll, have you applied for TERS with UIF? Just yes or no, and then we'll tell you what the people are saying. Okay. Thanks, Charles. Sorry to interrupt you there.
No problem. So when you go into the online portal, you'll register a profile. So you'll use your UIF reference number. Very important, your UIF reference number, not your pay-as-you-earn number or your U number received from SARS. It's your UIF reference number, your company number, and you'll input your company details. So it's very straightforward. It's like filling out a questionnaire, basically, which you will input all your details. You'll move to the next step, which is the MOA, which you need to accept. You can read through the whole MOA. It's up on the website, so you need to read through it, but you need to click accept before you can proceed.
And that's a standard document.
It's a standard document. It depends. Just to backtrack, I mentioned the bargaining councils earlier. So as some of you might know, there are various sectors within the labor industry in South Africa, and some of those sectors are governed by bargaining councils. So what the UIF has done is some bargaining councils are actually applying for TERS on behalf of the employers. So you need to see whether or not you are registered with a bargaining council, and you need to contact your bargaining council to find out, are they applying for TERS, or do you need to do it on an individual basis? Okay, so once that's done, if they are applying on your behalf, you can contact your bargaining council, and you can then you can contact your bargaining council. You can contact your bargaining council, and
this is now the employer, the business. If I'm a business,
yes, from a business perspective, you contact your bargaining council, and your bargaining council will then say, yes, we are applying. Then you need to apply through the bargaining council, not the Department of Labor.
Give me examples of bargaining councils. Give us some examples.
The textile industry, I know, is one of them that have applied. So if you belong to the textile bargaining council, you can approach them. I know the Road Freight Logistics Bargaining Council also applied for TERS, so you can contact them as well, because if the Bargaining Council applied and it's extended to you, as I said, you apply through them, not the Department of Labor. If the Bargaining Council does not apply, you do it through the Department of Labor. So we ended off by saying 61% of people.
I see we have our results here. 61% of our attendees today say that they have applied for TERS.
Correct.
39% no.
Most of them,
which of those have had payouts? I'm not sure. How long is that process?
It depends. Some have received payments within 48 hours. Others have taken 10 days. It all depends. There's no. Sorry?
On what does it depend?
The Department of Labor, honestly. And there's various other factors that also, outline the, did you fill in the forms correctly? Did you submit all the necessary documents? There's various things that could delay the process from the employer's side as well.
So who is eligible for the TERS? Who is allowed to apply?
That's also recently changed. Initially, when the TERS came out, it was for employers or companies only that are in financial distress, but they've now removed that. It's any company that has closed for or partially closed for the lockdown period. So to be eligible for TERS, there are a few requirements. You need to be able to prove that your shutdown or your temporary closure is directly linked to COVID-19. Furthermore, you also need to be registered with the UIF and in good standing with the UIF. That's also a very important aspect. I know I've got a lot of queries from different people saying, my employer is not claiming TERS because he hasn't paid me or paid over my UIF for the last 4 months. Unfortunately, that's something that you need to take up with your employer. That's not anything that anyone else can sort out from their side. You need to take that up with your employer, but there's various means of dealing with that as well. To get back to the process,
any business that's been affected, and I can't think of one that's not been affected one way or the other.
Correct, yes. I mean, even your retail stores that are open at the moment are still partially closed. They don't have all their departments up and running. So even they can claim for TERS for employees who are at home or not receiving their full income. I know Shirusha mentioned, and she said that it's, as far as she knows, that it's a payment of 3,500 across the board. That was the previous UIF benefit that was laid out, the natural disaster benefit. That's fallen away. As I stated earlier when I spoke, this has changed numerous times throughout the lockdown. So the current standing is you apply, they work out their percentage. No employee will be paid less than 3,500. That because according to the Department of Labor, that's the national minimum wage. So obviously it depends on the amount of hours an employee would normally work within a week or how their pay is structured, but no one should earn less than the national minimum wage. So that's the minimum that they'll pay out. And then the maximum is between a sliding scale of, they cap it at 17,712 Rand. They cap it and then they use the sliding scale for that amount as well. So it depends how the sliding scale falls on your part. I mean, I've had employers receiving large amounts and I've had employers receiving minimal amounts. It all depends on how the Department of Labor work it out. And unfortunately, in the MOA, it clearly says the UIF calculations will prevail. So what they say, that's the calculations that are used.
We'll chat about now if there's an appeal process, but if the attendees please join us. There's another poll saying, if you have applied for TERS, have you been successful? Have you received a response? So is there an appeal process? Not formally, no. The advice I'm currently giving to members is if there are any issues, and I can see there's a lot of issues that are coming through, the TERS does have support, a support email and a support call line, which you can contact. I know I've seen someone put in the chat there that they've been unsuccessful with it. Unfortunately, it is a department which is getting a lot of attention at the moment. So I can think that they're inundated with emails and the call centers are just crazy at the moment. So my advice is try again until you get through. Or alternatively, you can try and look for other email addresses for the Department of Labor. Try and email the regional office or your district office. Just try and get through by any means necessary and try and talk it out with them. It's exactly like Shirusha said with the landlords. Just don't make a unilateral decision from your side. Try and engage them and talk to them and see if you can talk things out. You can get a hold of them, right?
If you get a hold of them, obviously, yes.
So we do have a question from Brenda, which I think is quite, Brenda Kennedy said, they've been paid for their South African ID number staff only. They have staff, other staff that have work permits. So maybe a question around which staff qualifies for TERS.
All employees who are registered with the UIF and who have been contributing are eligible for TERS, and obviously they need to be have either suffered a financial income or are bound to suffer financial income or are part of a lockdown or shutdown company. So they didn't specify anything about only South Africans are allowed to claim. So what would happen there is obviously if the employees are registered with UIF, the employees on working permits, they should have added in some form of detail instead of a South African ID, whether it be a work permit or a passport number. I know the passport number is the general one to use. I would then insert that into the application process instead of trying to input an ID and do a second claim. If the second claim again is not successful, that's when I would then try and get a hold of the Department of Labor and have a discussion with them and say, guys, you've already paid out half of the staff, the other half aren't getting paid out. What do you guys want from me?
Okay, so maybe just, can you take us back to the sliding scales? I see there's some questions on the chat about how the sliding scales work. Can you explain that a little bit to us who don't understand it?
So what the Department of Labor does is they take your monthly salary and they apply a sliding scale to it. You see 56% have not received a response, 17% received a response but weren't successful, and 28% received a response and were successful. So that just goes to show there are people who are successful, but again, I think they're just inundated at the moment with queries, and that's why they're taking longer to get back. I know when you apply for TERS, they immediately send back an email and say, if you are successful, if everything meets the criteria, 10 working days, that's the turnaround time. So maybe give it 10 working days, and if it's not successful, you don't get anything, try and follow up. What I wanted to say about the sliding scale is what the Department of Labor does is they take your monthly salary and they apply a sliding scale to it, which is between 38% and 60%. So what that means is,
and that's the high, sorry, that's 38 to 60% of your gross monthly income.
Correct, yes, which they pay out, correct. So what that would mean is the higher your salary, the lower on the sliding scale you'll be, obviously. So if you receive a minimum income of 4,000 Rand, for example, you'll be at the higher end of the sliding scale. So they would pay out 60% of your salary, whereas the higher you go, for example, 17,000, they might only pay out 38%, but it depends on them and how they calculate it. I can't clearly state how they calculate it. I've asked around and no one seems to be able to give me an answer with regards to that, but that is how the process works.
Okay, and what about, so we've had businesses saying to us that they are now required to open a new bank account where the money from the TERS will be paid into.
That again, Karine, is one of the things that has changed. Only bargaining councils now need to open up separate banking accounts. Like I said, initially when the TERS came out, it was for everyone. Everyone had to open up separate bank accounts, but that's now changed and they'll pay it into your operational bank account. However, when looking at the MOA, you need to be very clear they have the right to audit and make sure that the funds they gave were distributed to the correct people and that it wasn't used for anything else.
Okay, I'm just looking at some questions here. What other kind of questions have you dealt with in this time from employers? So you spoke about leave, we've spoken about UIF.
The other one that I would maybe touch on, I know Shirusha touched on it as well, is financial distress. We open up, what happens? No one's going to hit the ground running. Well, very few businesses will hit the ground running in South Africa after the lockdown. We all are aware of this fact. The first word that jumps to mind is retrenchments. Retrenchments aren't the first go-to option. Just like Shirusha said, there's various other means which you can do. It's a consultation process. So personally, what I recommended to a few members is put them on short time. Rather give your employees some form of income than get rid of employees. So for example, what you would do is let's say you've got a staff complement of 10 employees. They all do generally the same work. Instead of saying, I need to retrench 5 employees because I can only afford 5, you could put them on 2 different teams. Have 5 employees work one day and 5 employees the next day. That would also cut your salaries and still secure their jobs. Again, like Shirusha said, this is by consultation. You can't just call all your staff together and say, guys, I'm now putting you all on short time. You need to give them a reason. You need to have discussions with them. You can't just unilaterally just put up a notice and say, from tomorrow we're doing short time. There needs to, I would recommend putting up a short-time policy. You can contact the GEO. They have a short-time policy with regards to that. Put in a short-time policy. Once the short-time policy is implemented, contact the employees, get them all together and just have a discussion and be open with it.
We have one more question here from Alison Jones saying, if your company is partially open and not all employees are working during this time, can you still apply for TERS?
Correct.
I assume for those that are not working.
Correct. You can also do, if employees are on short time, you can also apply for TERS to see if the Department of Labour will supplement the shortfall of salaries. But again, like I said, you need to put in there to say, I've paid my employees, my employee generally earns 5,000 Rand a month. I've paid my employee 3,000 Rand because he's worked reduced hours. So the shortfall is 2,000, and then they will obviously decide whether or not to supplement the shortfall. But for closed employees, definitely apply for TERS.
Thank you, Shoal. I just want to say Shoal joins us from the south coast of KwaZulu-Natal today. So I'm sure you feel like you're on holiday the whole time in lockdown.
Frequently.
Thank you, Shoal. Thank you, Sharusha. I think the one thread that runs through, whether it's with your landlord, with your debtors, your creditors, with your staff, is to communicate, to engage, and to keep on communicating. Thanks for joining us today and sharing your insights. Sean will just end off the session for us.
Thanks.
Yeah, guys, once again, thank you so much, Sharusha. Sharusha is from Bregman and Moodley Associate Attorneys. And Charles van Biljon, thank you for joining us. Karin, thank you for hosting the session as well. We may not have gotten to all your questions in the chat, so do stay online if you want to engage further in the chat. Our speakers will also be still available to answer any questions on the chat. We will be ending this Entrepreneurship to the Point session. It was here to inform, equip, and inspire you during this COVID lockdown period. Please do follow us on YouTube, subscribe to the channel at Entrepreneurship to the Point, or to our newsletter at www.ettp.co.za. Also, we have started an In Conversation series, which takes place at 2:30 every day. Today, we have a session on at 2:30, and the screen that you've seen at the moment is one for tomorrow, which is another session for 2:30. In the In Conversation series, we want to be able to speak not just about entrepreneurship and support for entrepreneurs, but speak to entrepreneurs that are currently going through this unprecedented challenge during the lockdown. So it's really being able to capture their stories and to share their journeys with those out there, and let us continue to support the small businesses during this time. Please, once again, join us at 2:30. For now, we will be ending the webinar, and see you soon. Cheers. I'm out of here.
Thank you. We're still answering some questions in the chat.
Yes.
Cannot wait for umfulo, ayakota malanga.